and then you proceed to stab him 25 times.
You're just not thinking about the fact that on the charges, he is ordered held without bond.
Get out of Brian hell, you piece of
As I was in there, an officer was.
In a deeply emotional and tense sentencing, Euan Dwit was given 40 years in prison for the brutal murder of Julie Minogue, a 40-year-old mother he attacked with an axe 13 times in December 2022 while her children were present. During the sentencing, Dwit initially sat quietly but lost control and began shouting when the prosecutor described his actions as cold and calculated. Marshals had to restrain him before the hearing continued.
Cold, calculated, well thought out to the extent that we could Uber.
Get out of Brian hell, you piece of
Watch your mouth.
Luke, who's a baby. He was in shock after.
Family members delivered heartbreaking statements, including Julie's mother, who expressed that even a life sentence would not be enough to account for the horror DeWitt inflicted on their family.
He denied me and my family the right to see my daughter, even before her funeral, because he mutilated.
Julie's father called DeWitt's apology empty words, saying he heard no true sorrow.
What did you think when you heard that?
Those are just words, okay? But read into the document that was prepared, I didn't hear much sorrow.
Prosecutors highlighted that DeWitt had sent hundreds of threatening messages before the murder and criticized Milford police for paperwork delays that might have prevented the killing.
On that very first court date, he looked at me and he asked me to remember the last minutes of his daughter's life and what she must have been going through.
I want to say I'm sorry. I snapped.
For Julie's family, the sentence at least means they no longer have to face DeWitt in court, but they say nothing can truly repair what he did. An Anderson County jury has sentenced Shaun Finnegan to death for the brutal 2011 murder of 35-year-old Jennifer Paxton. Prosecutors described how Finnegan kidnapped Paxton, held her captive in his Oak Ridge apartment, repeatedly raped and abused her, then strangled her to death. Afterward, he stored her body in a freezer for months and, according to testimony, viewed it for sexual gratification. Finnegan was found guilty of first-degree murder and numerous other charges, including aggravated kidnapping, abuse of a corpse, and tampering with evidence. He was acquitted on 2 lesser conspiracy counts. During sentencing, prosecutors told the jury Finnegan showed Paxton no mercy, asking them to give him the same.
Take a seat. Mr. Finnegan, you can stand up, please, sir, with your attorneys. Upon the verdict, the jury find you, Shaun Finnegan, to be guilty of murder in the first degree as charged in the indictment. Upon further verdict of fixing the punishment of death, it is therefore ordered that you shall be put to death by lethal injection in the mode prescribed by Tennessee law pursuant to the provisions of Tennessee Code annotated 40-23-114. You'll be transferred to the custody of the warden of the state penitentiary at Nashville, Tennessee, pending appellate review. Thank you. Have a seat, sir. And then also I'm going to sign the order that as the 13th juror, I accept and approve the sentencing and the verdict rendered by the jury.
The jury agreed, citing the cruel and heinous nature of his crimes. His defense team argued life in prison without parole would be enough, pointing out Finnegan's potential to work and contribute while incarcerated. After the verdict, Paxton's family and friends expressed relief that they would no longer have to endure court hearings about her horrific death, though they said no sentence could ever truly balance what Finnegan did. In San Antonio, Sebastian Hernandez was sentenced to 32 years in prison for the 2021 stabbing death of Christopher Olivares, a crime that left Olivares' family devastated. Hernandez, who met Olivares through a dating app, claimed he stabbed Olivares after allegedly taking a knife away from him during a marijuana smoking meetup.
It's over with now. I mean, it's over.
Hernandez pleaded no contest in August as part of a plea agreement, hoping for leniency at sentencing. However, the judge imposed the maximum sentence, citing strong physical evidence, including Hernandez's DNA on the murder weapon.
After you disarmed him, he no longer has a weapon, right? According to you. And then you proceed to stab him 25 times.
Here's my thinking.
Olivares' mother, Mary Coronado, spoke through a prosecutor during the sentencing, saying she wanted Hernandez to be haunted by what he did to her son. She says she cannot forgive him, feeling he showed no remorse. Hernandez cannot appeal because of the plea deal, but he will be eligible for parole after serving half of his sentence. In North Carolina, 16-year-old Shaun Simpson broke down in court after learning he would be charged as an adult for first-degree murder. Simpson is accused of fatally shooting 16-year-old Zaquavius Dawkins in Gastonia on January 26th while Dawkins was walking with a friend to pick up items for his disabled mother. According to reports, Simpson was in the back of a black Tesla when he allegedly yelled at Dawkins before opening fire. He was arrested 2 days later at a treatment center for youth with emotional and behavioral issues. In court, Simpson sobbed and needed to be supported by officers as a judge denied him bail, appointed him a capital defender, and confirmed he would face adult charges.
On the charges, he is ordered held without bond, pending indictment and grand jury. All right.
His cries of, "I love you, mama," echoed through the courtroom as he was led away. The victim's family described Dawkins as kind and loving and said his death has devastated both their family and the entire neighborhood. Simpson is believed to be among the first teens prosecuted under a new state law allowing 16 and 17-year-olds to be charged as adults for serious felonies, including murder. He now awaits possible indictment by a grand jury. More than 2 years after a deadly rock-throwing spree in Jefferson County, 20-year-old Alexa Bartell's killer has been sentenced. Nicholas Carell, who admitted he and friends threw rocks at cars that night, appeared in court and received a 45-year prison sentence. In April 2023, a large rock thrown by Carell struck Bartell's windshield, killing her. He pleaded guilty to second-degree murder, criminal attempt in the first degree, and a crime of violence enhancement. During sentencing, Alexa's grieving family described how their lives have been forever changed, saying they will never again hold her, hear her laugh, or watch her experience the life she deserved.
The brutal reality that I will never again hold my daughter in my arms, hear her laugh, or watch her experience the life she should have had. It haunts me every single day.
Alexa was my everything in life. She was my pride and joy. She was a beautiful person inside and out. She was a very respectful, loving, kind, caring, thoughtful, fun, intelligent young lady.
Her mother called Alexa her pride and joy, and a kind, loving, and thoughtful young woman. Jennifer Carvajal, who already had a deadly drunk driving conviction in her past, was sentenced to 67.5 years in prison for a horrific DUI crash in April 2021 that killed her cousin, Pedro Carvajal, and injured 2 other people. At the time, Carvajal was driving 110 miles per hour on I-4 with a blood alcohol level nearly twice the legal limit, crashing into a car dealership.
So the entire room smelled like alcohol?
Yes, it smelled like a brewery.
The judge described her behavior as taking affirmative steps to repeat her deadly choices instead of avoiding them, even though she was still on probation from a previous fatal DUI case for which she had served 4 years.
She has now committed 2 acts of DUI and taken 2 people's lives while doing it.
Family members of the victims gave emotional testimony about their devastating loss, while Carvajal tearfully apologized in court, saying she could never forgive herself.
Devastating for me and my family to think about what it would be like to still have him here.
And no matter how many sorries I say to each of you, or even him, I could never forgive myself.
Her defense highlighted her history of childhood sexual abuse and alcoholism, but the judge ultimately imposed a sentence that will likely keep her behind bars for life.
It's almost as if instead of taking every step to avoid putting yourself in that situation again, you took affirmative steps to ensure that it happened.
she had turned down a 50-year plea offer before trial, and on top of the new sentence, was also given 15 years for violating probation in the previous manslaughter case. Thomas Godinez, now 51, was executed in Florida on June 24th after being convicted 3 decades ago of raping and murdering 27-year-old Michelle McGrath in downtown Orlando. Back on May 24th, 1994, McGrath was last seen leaving a nightclub around 2:45 a.m. before being attacked while walking to her car. Police later found her bludgeoned body in an alley off Washington Street.
I'd always look at them and read them, and I'd be like, why do you keep looking at them? He's like, well, I'm looking just to make sure my name's not on there. I was like, did you girl, Tom? And he looked at me and he goes, what if I did? And I go, you're stupid if you...
Godinez's cousin testified during the 1995 trial that Godinez confessed to killing McGrath, dragging her into an alley, and committing sexual acts with her corpse. That testimony, along with fingerprint evidence, was key in convicting him and securing the death sentence.
I said, well, did you have sex with her when she was dead? Yeah, just joking around. I apologize to the family for that. I was stupid. But,
Do you recall telling the police that you said, yeah, I her, then...
Yeah.
Do you remember now if that's what he said?
Yeah.
Governor Ron DeSantis had signed Godinez's death warrant earlier in the month, scheduling the execution for June 24th, almost exactly 31 years after the crime. A Greensboro man who spent over 25 years in prison is now free. Benjamin Cole, convicted in 1999 of killing Calvin Jenkins, maintained his innocence and accepted an Alford plea, which allowed him to plead guilty to a lesser charge without admitting guilt. New evidence revealed prosecutors and police withheld hundreds of pages of files showing Cole was in an Ohio recording studio when the murder happened. A key witness also testified she would not have identified Cole if she had known about his Jamaican accent, saying the killer had a Southern accent. Judge Susan Bray ordered Cole released, crediting his decades in custody.
He does have the jail credit that covers his sentence. So he is released from custody now.
Well, you saw the joy, you saw the hug, and we're just happy that he's had that opportunity. I think he was a bit overwhelmed, understandably. His first time walking into freedom after all that time. So we're grateful that he was able to have that emotional moment with his mom, his legal team, hugs all around. And he can't wait to drive away and to experience freedom after all those years.
Surrounded by hugs from his family and legal team, Cole finally walked free, keeping his promise to grow his hair until he was exonerated. A 24-year-old man accused of taking the lives of his parents and teenage sister and injuring the family dog in Tijeras appeared before a judge. Deputies say they found Adla Mestre at the scene covered in blood, with a weapon nearby, after a landlord reported hearing gunshots.
You could see drag marks, blood that went over various bushes and trees and down into the ravine.
BCSO described a brutal scene with the victims' bodies found face down in a ravine, showing gunshot wounds and blunt force trauma. Investigators also recovered 10 shell casings and noted Mestre had tried to clean up the crime scene.
And we located them in the ravine face down, lying on top of one another.
The family dog, shot 3 times, was later euthanized. In court, Mestre interrupted proceedings, insisting his medication had been stolen and claiming bizarre things about his family's bodies. Prosecutors showed video of Mestre kicking through a wall at the sheriff's station as evidence of his volatility. Despite arguments from his attorney to release him under supervision, the judge ordered Mestre to remain in jail, citing the risk he poses to the community.
I have a lot I have to say. May the media please get pictures of the because my father was throwing this up and my mother was throwing this up, and their wounds were healed and blackened. May the media, may you please release the photos to the media because I'm fighting for my life.
Mestre faces charges including 3 counts of murder, animal cruelty, and escape. Raymond Childs III will spend the rest of his life in prison after being sentenced to 360 years for murdering 6 family members in their Indianapolis home in 2021. Childs was just 17 at the time of the fatal shooting, which claimed the lives of his parents, his 13-year-old sister, his 18-year-old brother, and the brother's 19-year-old pregnant girlfriend. A 15-year-old brother survived after being shot twice.
I cannot comprehend the darkness in your heart at that time that led you to commit such an unfortunate act on January 24th. What I do know is that our lives changed forever on this date, and you robbed us of everything we had.
Childs maintains he is innocent, telling a packed courtroom he didn't commit the murders.
As I sit here 4 years ago, I'm innocent. It's not a day that goes by where I don't think about them or wish that they was here. Even on my bad days, I tell myself that they're still here.
But the judge called the killings cold-blooded and calculated, handing down consecutive sentences. 55 years for each victim, including the unborn baby, and 30 years for the attempted murder of his surviving brother. Evidence included cell phone records, the murder weapon, and testimony from Child's surviving brother identifying him in court.
The evidence in this case could fairly be characterized as overwhelming. There was cell phone evidence. He was caught with weapon, and most compellingly, his own brother identified him in open court, and it would have been nice if he had expressed some remorse about what happened.
Everything that he said, I believe. So, I don't too much believe justice was served, but I do hope that they do find the real people that did.
Despite the defense citing Child's history of trauma and PTSD, the court found the evidence overwhelming. Child says he plans to appeal. A Texas man accused of strangling his pregnant wife is being held on a $1 million bond. Lee Jilly, a 38-year-old computer consultant, is charged with capital murder in the death of his wife, Krista, who was 9 weeks pregnant with their third child.
Does that mean I'm getting a bond today?
Initially, Jilly told 911 that Krista had overdosed, but an autopsy revealed she'd been strangled and showed bruising and trauma on her face.
Most people are shocked that this is happening to women at the frequency that it is. Just being pregnant increases your risk of this thing happening.
Police say the couple argued earlier that day over buying a vehicle. Krista's best friend described her as a devoted mother excited to welcome another baby.
Krista was the best mom, and that's what she lived for. She was so excited to have a third child.
Jilly faces life in prison or the death penalty if convicted. A Washington County court hearing went viral after a trespassing suspect cursed at the judge and ended up getting nearly 2 years in jail for contempt of court. Darrell Gerald, facing a misdemeanor trespassing charge, interrupted as the judge was about to dismiss the case, angrily swearing at Judge Cedric Simpson.
I could technically leave and you guys could issue a warrant as long as I don't return. You can just kiss me. This is
you know what? No. I'm gonna tell you what. You don't come. You don't. Okay, that's contempt. That's 93. That's another 3. That's another 93. That's another 93. That's another 90. That's 6 93s consecutive.
In response, the judge repeatedly sentenced him to 93 days for contempt, 6 times in a row, totaling 558 days behind bars.
That's another 93. That's another 93. That's another 90. That's 6 93s consecutive.
The moment stunned others on the virtual hearing, with one man visibly reacting in disbelief as the judge handed down each 93-day term. This isn't the first wild moment for Judge Simpson, who earlier this year had a suspended license case involving a man who dialed into court while driving. 2 decades after being sent to prison for murdering his pregnant wife, Lacey, Scott Peterson is speaking out in a new Peacock docuseries, Face to Face. Now 51, Peterson maintains his innocence, claiming police ignored critical evidence that could exonerate him. In 2004, he was sentenced to death for the 2002 murders of Lacey and their unborn son Connor, after their bodies were found in San Francisco Bay, near where Peterson said he'd been fishing. The sentence was later reduced to life without parole in 2020.
I wish I could say I was stronger, but all that stuff did take a toll on me.
In the series, Peterson describes the shock of his conviction, saying he truly expected to go home, and denies the prosecution's theory that he killed Lacey to escape fatherhood and marriage.
was still expecting to go home that day. I was staggered by it.
There are certainly times that I become a wreck.
He expressed regret for cheating on her, but insisted that didn't make him a murderer. Peterson's defense is now backed by the LA Innocence Project, which is pushing for a new trial.
I was so angry at the media because their reports just weren't factual. I strive not to show any emotion in the court because I didn't want to, see them break me.
They said that you Lacey because you didn't want to be married and you didn't want to be a father.
That's so offensive. It's so disgusting.
They argue that burglars across the street killed Lacey and claim new witnesses saw her walking the dog after Peterson left the house.
I was searching for my family, stay in contact with Amber, I thought, and she wouldn't get into the picture, complicate, ruin the search. I believe that Lacey went over there to see what was going on. That's when she was taken.
The court has agreed to allow DNA testing of duct tape found on Lacey's body, which was never tested before. In the tragic case of Penny Pizarro, the man who killed her while driving high on meth has been sentenced. John Bearden Jr., who crashed a stolen SUV in March 2023, killing Penny and injuring her father, appeared tearful in court as he apologized to the Pizarro family.
Clearly your pain is palpable and strong, and I hear you and I see you, and I really am sorry for your loss.
I just again want to send my condolences, and I think about you guys every day, and I think about Penelope, and I'm so sorry.
I am going to designate count 2 as an SVO. For one, I'll start there.
Judge Jennifer Warner Boach gave him a 22-year prison sentence, requiring him to serve at least 85% of that time, followed by 5 years of supervised probation. That was close to the maximum 27-year sentence he faced.
I do think that there has to be an adequate sentence to acknowledge, that there were chances along the way and those chances were not taken, and to recognize the value of the life that was lost.
Family and friends showed up wearing pink, Penny's favorite color, and shared plans to launch a nonprofit in her memory to help other victims' families.
But I'm grateful for all the work that the DA has done. I know they put all their heart and soul into it, so I believe it was fair.
Bearden's attorney also asked that he serve his sentence at a specialized sex offender facility in Otero County, arguing he could be at risk in the general prison population. Anton Reagan has been sentenced to life in prison without the possibility of parole after jurors convicted him last month of first-degree murder for the 2013 shooting death of 21-year-old Luis Perez at a North Miami motel.
We, the jury, finds as follows. Defendant is guilty of first-degree premeditated murder as charged in the indictment.
The same jury returned Thursday afternoon for the penalty phase, where they deliberated for about 2 hours before choosing life in prison over the death penalty.
To prove the crime of first-degree premeditated, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Luis Perez is dead. Number 2, the death was caused by the criminal act of Antoine Reagan. Number 3, there was a premeditated of Luis Perez.
During the trial, prosecutors argued the murder was cold, calculated, and premeditated, citing Reagan's history of violent crimes, including other shootings and threats.
Admitted to the plan, and he executed his plan.
The defense presented mitigating evidence about Reagan's troubled childhood, mental health issues, and difficult upbringing.
Shot, brachial plexus.
Reagan declined to testify at any point during the proceedings.
All of those casings were fired from the same 9mm firearm.
I refused in chest.
His accomplice, Terry Neely, refused to testify in person, but had prior statements read to the jury implicating Reagan as the gunman.
So that was Mr. Reagan that Mr. Perez first?
Yeah.
A lot of assume this, assume that.
Ultimately, jurors found that life without parole was appropriate punishment, concluding a case that had been in the courts for more than a decade. A shocking attack unfolded in Manhattan criminal court as surveillance video captured a man calmly approaching the metal detectors before suddenly lunging at court officers with what appeared to be a knife.
911, 100 Center Street, for officer stabbed at the location.
In the chaos, 2 officers were stabbed and a third was injured as they struggled to subdue the attacker. The motive for the attack is still unclear. Eyewitnesses described seeing at least one officer with a gash on his face.
As I was in there, an officer was
I'm not sure how bad it was. I did see that there might have been a gash on his face.
Court officials confirmed the suspect was quickly taken into custody. The violence happened at the same courthouse where high-profile trials, including those of Harvey Weinstein and former President Trump, have taken place. Court officers' union leaders called the incident a wake-up call, pointing to severe security deficiencies in the system and urging stronger protections for those who keep the courthouse secure. The man who killed Hartford Police Detective Bobby Garton nearly 2 years ago has been sentenced. A judge handed Richard Bington a 30-year sentence for manslaughter and assault, of which he will serve 16 years in prison, followed by 5 years of probation. Bington had pleaded guilty to the charges. Prosecutors say he was high on marijuana when he fled from officers, ran 2 red lights, and slammed into Garton's cruiser, killing Garton and seriously injuring Detective Brian Kearney.
Were the defendant's headlights the last thing Bobby saw on Earth? Was he afraid? Those thoughts haunt me.
In court, Bobby Garton's mother and other family members shared heartbreaking statements, wondering if Bobby's final moments were filled with fear. Bington himself apologized to the families, telling them he was deeply sorry for their pain and grief.
I want to apologize for all the days and the months and the years of pain and grief that I've caused and are currently causing. No mother, father, sibling, kid, or friend should have to endure the pain and grief you're enduring.
As a powerful reminder of Garton's sacrifice, Bington was led in and out of court wearing Garton's own handcuffs. A Grand Rapids man will spend decades behind bars for claiming the life of a young mother. Anthony Buxton was sentenced today for the September shooting of 25-year-old Nevia Howard Browley. Prosecutors say Buxton and Browley were arguing outside his home on Bluebird Avenue when he fired at her. The judge handed Buxton a prison term of at least 21 years and 8 months, with a maximum of 35 years. During the sentencing, Browley's mother shared the heartbreak of watching her grandson cope with losing his mother.
She was best mom to a little boy who wakes up every day and says that he loves Jesus because that's who takes care of her now.
Buxton did offer an apology to the family in court. An Albuquerque man who committed 2 brutal murders before he even turned 20 has been handed his second life sentence. A judge sentenced Isaiah Garcia for the demise of 21-year-old Kayla Campos, who was fatally injured in 2019 while playing Pokemon Go with her boyfriend in Bianchetti Park. Campos was hit by a bullet in the neck and crashed her car, dying at the scene. Her devastated family addressed the court, describing Kayla as the glue of their family and pleading for the maximum penalty.
She was tough but gentle, intelligent but understanding. Her life would be an amazing journey to continue to watch. But now that it's been taken from us, it's in your hands to decide, Your Honor, the sentence of my daughter. We humbly ask for the maximum penalty.
Garcia was already serving life for murdering 17-year-old Sean Marquis at a house party the same year. He had hoped the sentences would run at the same time, meaning he could be eligible for parole in his early 50s. But instead, Judge Joseph Montano ordered the second life sentence to be served consecutively, ensuring Garcia spends the rest of his life behind bars.
Today, she would have been 26 years old, and I can't help but think about all the unanswered questions regarding which milestones she would have reached by now.
The judge called Garcia's crimes violent acts against innocent children. Garcia spoke in court, maintaining his innocence in Campos's killing, but extended condolences to her family.
It is because of these violent acts against innocent children. They are truly children, Judge. Violent acts against children, that he remain in custody for the rest of his life.
On top of the 2 life sentences, he was also sentenced to 13 additional years for other crimes, including armed robbery and shooting at a motor vehicle. A Michigan family is outraged after the teenager who caused their son's death in a horrific high-speed crash was sentenced to what they see as basically a slap on the wrist. Flynn McCrell, 18, was killed last November when his friend, Kieran Tag, crashed while going 105 miles per hour in a 25 miles per hour zone. Mackerel's family asked the judge to try Tag as an adult and give him the maximum 15-year adult prison sentence. Instead, the judge sentenced Tag to just 19 to 38 months in a juvenile detention facility as long as he behaves. In court, Mackerel's parents, sister, and brother gave heartbreaking victim impact statements describing how Flynn's death shattered their lives.
It wasn't until I stood over my brother's coffin and held his lifeless hand that I started to awaken to the devastating reality that now is my everyday life.
I am here to fight for the justice Flynn deserves, to ensure that someone as callous as Mr. Tag does not have the opportunity to rip away another innocent life.
They argued Tag showed little remorse and said his repeated reckless driving made him dangerous.
Mr. Tag is manipulative, deceitful, violent, dishonorable, selfish man.
Judge, I'm going to object.
This is not, yes, I'm going to sustain that.
Your Honor, if I could send a message to the version of myself that existed nearly 2 years ago, my 16-year-old self, I would tell him to be careful. I would tell him that life is precious and that can change in an instant. I would tell him that there is nothing, I repeat, nothing, worth the pain and suffering that this has caused for the world.
Flynn's mother called Tag a homicidal maniac and said she felt deeply betrayed by the justice system. Tag told the court he had changed and expressed regret, but Flynn's family rejected that as insincere.
Polite, manipulative, that is the biggest betrayal. It's a cunning, manipulative criminal individual who just once again was not held accountable for my son.
They now want to see laws changed to hold parents accountable when teens repeatedly speed and to toughen penalties for reckless young drivers before another family goes through a similar tragedy. In Cincinnati, a heartbreaking chain of events unfolded when Rodney Hinton Jr. allegedly drove into and killed a Hamilton County Sheriff's deputy who was working traffic duty outside the University of Cincinnati's commencement. Hinton, 38, has been charged with aggravated murder and is being held without bail at the Clermont County Jail. This happened just one day after Hinton's 18-year-old son, Ryan Hinton, was fatally wounded by a Cincinnati police officer during a stolen car chase. Ryan ran from police, who said he was armed, though there is no evidence he fired a weapon. Officers reported finding a weapon with an extended magazine near his body. Dozens of deputies packed the courtroom Saturday in support of their fallen colleague.
The municipal court is now in session. Judge Tyrone Yates is presiding this morning. We ask that you turn off all cell phones. You may be seated. Please remain quiet during all proceedings.
Good morning. Good morning, everyone.
Good morning.
Good morning. Good morning, Your Honor. Good morning. Good morning.
Good morning, Your Honor. First case load out to Rodney Hinton.
Okay. Thank you. Good morning, Mr. Hinton. Good morning.
He said good morning, Judge. He's very soft-spoken.
Okay. All right. Thank you. All right. Anything as to probable cause?
Your Honor, we'll waive probable cause this morning. I have submitted designations for John Kennedy and Timothy Bicknell. They will be the attorneys of record handling Mr. Hinton's case. I'll be handling the arraignment this morning.
All right, thank you. Mr. Prosecutor, or anything as to bond?
As to bond, Your Honor, thank you. Your Honor, we understand this is a very, very serious, very terrible charge that Mr. Hinton is facing. He has a risk, but he does not have a history, Judge. He has no felonies in his record. His risk assessment score was a 1. He had no juvenile record. He works at UDF. He's married. He's a father. He's a graduate of Purcell Marion. I understand that this is an emotionally charged situation. I understand that Mr. Hinton's son have been by the police earlier in the week. There was a review of that video. I understand that there is a lot of sadness and a lot of anger in this room right now, but in the community at large. And we just ask the court to set a reasonable bond in light of everything and to allow the constitutional process to play out.
All right, thank you.
Cincinnati Police Chief Teresa Thiege called for patience, urging the community to let investigations run their course with transparency.
Andy, you've given me a pre-trial services sheet. Is that right this morning? All right, the court has had a chance to review that and his past history. Is there anything from the state through the prosecutor?
Yes, Your Honor. Ryan Nelson on behalf of the prosecution.
Could you give us more volume, please?
Yes, Your Honor. Ryan Nelson on behalf of the prosecution. What we believe that the evidence will show is that yesterday, on or about the 2nd of May, the defendant was traveling, I believe it would be eastbound on Martin Luther King Avenue at MLK, I believe at Burnett Woods at the intersection, I believe immediately north to the rear entrance of the University of Cincinnati. The defendant stops his car. The defendant, in a way that was calculated and premeditated, lined up his car, deliberately accelerated his car, and purposely caused an on-duty deputy sheriff who was doing a detail at that intersection. As such, we are going to be seeking indictment for aggravated, and we would request, in accordance with ORC 2937-222, for a no bond hearing. That rule requires that hearing be set within 3 business days, so we are seeking to set that date on the 6th of May of 2025, that would be next Tuesday.
Former FOP President Dan Hills described the deputy's death as murder and pushed for the death penalty. Both investigations are still ongoing. A Woodbury police officer remains hospitalized after a brutal attack, and the man accused of trying to kill him has been given a $3 million bail. Prosecutors say 33-year-old Tyler Wilmont targeted Officer Tim Wright in what they described as an attempted assassination, repeatedly stabbing Wright in the neck and throat on North Main Street during a traffic stop for a license plate issue. Wilmont reportedly approached the officer as he got out of his cruiser and launched the attack.
This was an attempted assassination. He targeted this officer. He wanted to kill this officer, and it came within 1 millimeter of this officer.
Officer Wright, a decorated veteran of the department who previously received the Medal of Bravery in 2014, survived thanks only to the quick actions of fellow officers who rushed him to the hospitals as he was choking on blood. Court documents reveal Wilmont had been arrested twice before by Officer Wright, including once on a deadly weapons charge and another for assaulting an officer.
Yesterday afternoon, after his arrest, this defendant made comments on body cameras to the police several hours later. Is he yet? And I hope he.
Wilmont also faces unrelated violent charges in California for allegedly beating a man with a tire iron. He has been ordered to undergo a mental health evaluation and will return to court next week. Meanwhile, Officer Wright is still struggling to recover and remains hospitalized, with loved ones saying he is having difficulty even holding his head up. Brody Brownell, who was 17 at the time of the crime, has been sentenced to 25 years in prison for the brutal murder of 64-year-old Leonard Williams in Lakewood. According to prosecutors, Brownell had been drunk and high at a party when he started picking fights. He then encountered Williams, a stranger simply walking through his apartment parking lot. Brownell viciously beat and stomped Williams, recorded a video of the attack on Snapchat, and sent it to someone. Afterward, he returned to the party, grabbed a kitchen knife, and went back outside to stab Williams 6 or 7 times, ultimately ending his life.
That night, he was a victim of a horrific crime. The defendant would later send a Snapchat video of this brutal beating to an individual in which he's filming the beating.
Friends described Williams as a kind, gentle person who enjoyed simple activities like having coffee with neighbors and gardening.
It was the most horrific thing, and it still haunts me to this day. Every Friday we had coffee together. We planted plants, but Leonard didn't deserve what happened to him at all.
In court, Brownell, now 19, apologized and blamed his intoxication, saying he was not in his right mind.
If I could go back and change my actions, I would. Very very intoxicated and just I wasn't there. I wasn't in my right mind. I just wanted you guys to know that I'm sorry.
The judge described the crime as deliberate and horrific, noting Brownell had multiple opportunities to stop but chose to escalate. He was given the maximum sentence of 25 years, with the hope he might learn compassion behind bars. Shaun Go, a Stark County man convicted of murdering his 24-year-old girlfriend, Rachel Sheridan, was sentenced to 29 years to life in prison. Stark County Judge Frank Forcione called it the most brutal murder he had seen. Investigators say Go beat Sheridan so severely that she was unrecognizable to responding deputies. After killing her, he wrapped her body in a sheet and dumped it in a park near Mother Goose Land, treating her like a piece of garbage, according to the judge. Sheridan was reported missing July 2nd, and Go was later seen driving her maroon Jeep Liberty. When stopped by deputies, he fled on foot and was arrested the next morning at a homeless shelter on unrelated warrants.
Lisa Sheridan.
Please proceed.
My fiance and I would like to give our statement. Shaun, to begin, I would just like to say that you have hurt us more than anyone else could have. You have taken one of the greatest joys in our lives. She was a true sunflower in our darkest days. You have our baby girl. My question is, why would you do this to someone that loved you, who wanted to help you through your own personal battles? She stood by you regardless of what you did to her. When you had no one else, she truly loved you. And just thinking of this makes me sick to my stomach.
Authorities determined Sheridan had been killed inside the apartment the two shared. Her body was found by sanitation workers on July 3rd. A Stark County jury found Go guilty of 2 counts of murder, felonious assault, tampering with evidence, and gross abuse of a corpse.
Truth be told, we had our own issues when she was grown up, but it made us stronger. There is no greater bond than that of a parent and a child. You brutally stole that from us. It won't bring Rachel back, but you have crushed all of our hearts. We won't be able to see her happily married. I used to smile, but you have taken all of that away. What you have done to us is truly evil. I hope that you spend the rest of your miserable life in prison. At least you are alive and your family will get to visit with you. I truly am so angry that I don't think I will ever be able to forgive you. And I hope that Jesus will.
Sheridan's mother showed Go photos of her daughter in court, and Go's mother also spoke, citing his troubled childhood.
Thank you.
Go will not be eligible for parole until he has served at least 29 years. A jury has found 24-year-old Joseph Nolan guilty of first-degree murder in the 2022 killing of 16-year-old James Sanchez. during a drug deal near a park in Catalina. The jury also convicted Nolan of attempted armed robbery and attempted aggravated robbery. Prosecutors argued that Nolan, along with 5 other people, went to Catalina for a drug deal that turned fatal. Sanchez was shot while inside a vehicle. Nolan admitted he fired at the vehicle, claiming he saw an assault rifle pointed at him, but prosecutors maintained he played a major role in the killing.
We, the jury, duly impaneled and sworn in the above action, entitled action upon our oaths, do find the defendant, Joseph Michael Nolan, guilty of the offense of first-degree murder, and guilty of the lesser-included offense of attempted armed robbery, and guilty of the lesser-included offense of attempted aggravated robbery.
The verdict came after about 3 weeks of testimony and deliberations that began late yesterday. Nolan showed little visible reaction as the verdict was read. John Patrick Shee has been sentenced to life in prison for the 2023 murder of Jillian Agner, a young mother and Bluffton pharmacy worker. According to investigators, Agner was taking her son to school when Shay, who had previously dated her, ambushed her near her home, shooting multiple times into her vehicle. Agner was initially taken to a local hospital, then flown to Savannah, but ultimately died after spending 5 months hospitalized. Her son had to witness his mother's prolonged suffering and death, an impact described as devastating by prosecutors in court. Shay pleaded guilty just as his trial was entering its 2nd day.
Mother were ripped away from him by the selfish acts of this defendant, with no regard for the impact that it would have on everybody who's part of Jillian's life. Month by month, his mother slowly withered away in a hospital bed. He was given a small shred of hope when he learned that paramedics had brought her back to life, but it was once again ripped away from him.
Alongside the life sentence for murder, he was also sentenced to more than 30 additional years for 2 gun-related charges and attempted murder. Ashanti Davis, 26, was sentenced to 7.5 years in prison, plus 5 years of extended supervision after pleading no contest in a murder-for-hire scheme that left her on-again, off-again boyfriend, Burnell Hall, dead.
Burnell's death was not an accident, not a moment of chaos. It was planned and calculated.
She's pled no contest, but she has not really taken accountability for what she's done.
I apologize. I would take accountability as a grown woman. I just want to say I'm sorry.
Prosecutors say Davis staged a fake robbery last November, luring Hall to a location where he was struck 3 times in the head by 2 masked men. Suspicion remains about who exactly fired the fatal rounds, but authorities say there isn't enough evidence yet to charge those suspected gunmen.
Why would they rob and somebody and not take the cash that is in his hand? Why essentially execute Mr. Hall and leave Miss Davis almost completely unharmed? Investigation into that is ongoing.
A woman who has been crying out for years may or may not have got what she wanted.
Davis insisted in court that she didn't fully understand what was arranged in phone calls before and after the shooting. But Hall's family believes she was part of a calculated betrayal.
You're part of this conspiracy in order to... He was ambushed, betrayed, and someone he trusted. I just want justice, and I just hope that the court can see what we see.
The investigation continues, with prosecutors relying on cell tower and cell phone data to try to identify and charge the actual shooters. 3 alleged gang members, Josiah Hewley, David Booker, and Miles Collins, have been found guilty on all counts in the 2022 murder of Bradley Coleman. Gwinnett County Superior Court Judge Tamala Adkins delivered the sentences, giving each defendant life without the possibility of parole. Bradley Coleman, 29, was a father, teacher, and coach visiting family in Georgia from New Orleans, so his daughter could spend time with her grandparents. On July 10, 2022, while using the air pump at a Quick Trip in Peachtree Corners, Coleman was approached by the men attempting to steal his car. Prosecutors said Hewley pulled the trigger, Booker acted as armed support, and Collins was the getaway driver.
Josiah Hewley. I can't see him. Mr. Hewley, count 1, felony murder. I sentence you to life without the possibility of parole. Count 2, violation of Street Gang Prevention Act. I sentence you to 20 years consecutive to count 1. Count 3, violation of Street Gang Prevention Act, I sentence you to 20 years consecutive to count 2. Count 10, hijacking a motor vehicle, I sentence you to 20 years consecutive to count 3. Count 11, violation of Street Gang Prevention Act, I sentence you to 20 years consecutive to count 10. Count 12, violation of Street Gang Prevention Act, I sentence you to 20 years consecutive to count 11. Count 13, possession of a firearm during the commission of a felony, I sentence you to 5 years consecutive to count 12. Count 14, violation of Street Gang Prevention Act, I sentence you to 20 years consecutive to count 13. Count 15, violation of Street Gang Prevention Act, I sentence you to 20 years consecutive to count 14.
Coleman was a respected community figure who had been a standout athlete at Norcross High School, earning a scholarship to Southern University and returning to Georgia to coach high school football. Loved ones described him as a gentle giant with a heart of gold and a devoted father.
Mr. Hewley, you have now been convicted of 15 felonies, 6 of which either merge or vacate as an operation of law, so you'll be sentenced on 9 felonies. I need to inform you that you have the right to seek post-judgment relief from your felony convictions by either filing a direct appeal to a higher appellate court or to file a motion for new trial. You have 30 days from the date I sign and file your sentence with the clerk, which should be tomorrow, to file a motion for new trial to any or all of the felony charges. Ms. Drake, will you be filing a motion for new trial?
Yes, ma'am, and I did explain to my client why my appointment could not or should not continue on this case, and I would ask the court to appoint him appellate counsel.
Right.
In emotional victim impact statements, Coleman's family shared their heartbreak and memories of his many achievements, with his brother Jeffrey and his mother Venetia addressing the court together. Venetia described her son's positive legacy, the deep bond he shared with his daughter, and the devastating loss their family will carry.
Mr. Hewley, as Ms. Drake has probably explained to you, your appellate counsel will review everything, including Ms. Drake's representation of you, to make sure that all your appellate rights are pursued. You also have 4 years from the date your sentence is final with this court, which should be tomorrow, to file a habeas corpus. I will appoint an appellate attorney who will be in contact with you and explain all these procedures to you. You just need to know the time frame, and Ms. Drake is going to file the appropriate motion so that the 30 days does not run.
Your Honor, may I just ask the court's preference if you would like for the attorneys to file motions to withdraw with our motions for new trial, or just...
It's not necessary.
Yes, ma'am.
It's not necessary. I'll just appoint appellate counsel.
Yes, ma'am.
Probably tomorrow.
Yes, ma'am.
Actually, I think I have to wait until you file the motion to appoint them. So it won't be tomorrow. But Mr. Hewley, I will appoint you appellate counsel. Thank you. You can go with the deputies.
Thank you, Your Honor.
Thank you, Ms. Drake.
Judge Adkins imposed the maximum sentence allowed under the law, ensuring all 3 men will spend the rest of their lives in prison. In Jacksonville, 2 suspects, Daniel Larkins, 20, and Keith Johnson, 21, pleaded not guilty Thursday to second-degree murder, conspiracy to commit murder, and first-degree attempted murder charges in connection with the demise of 7-year-old Breon Allen. Breon Allen was killed on January 24th in a drive-by shooting on Commonwealth Avenue that also seriously injured his 21-year-old cousin, Lafayette Mango.
Judge, if you could also get the picture of the Zoom is up. I know
it is up, and my mic is on, so they should be able to hear me.
Perfect. Thank you, Judge.
All right, and the individuals for the record are on Zoom as well. Mr. Larkins is present. We're here for arraignment.
Your Honor, on behalf of Mr. Larkins, we'd acknowledge receipt of a 3-count information in case 1625 CF 2392, We'd waive a formal reading of that information, reserving a right to attack its legal sufficiency at a later date, and are pleased of not guilty to all counts.
Police say the shooting was gang-related, targeting a rival gang member associated with ATK, while the suspects belonged to rapper Fulio's group, 6 Block. The Jacksonville Sheriff's Office called the shooting a planned act of bloodshed and emphasized that Breon was simply an innocent child caught in the violence.
All right, I'll accept a plea not guilty at this time. Just speedy would be the only thing I'd...
Judge, it's September 3rd.
All right, with speedy September 3rd, and we'll try and get different dates, correct, on
Yes.
each of these? All right. Mr. Eller, I would look for a first pretrial to April 29th, if that works. It's a Tuesday.
That works, Judge. Thank you.
So, April 29th?
That works, Judge.
All right, and then I'm sure there's family members here. Thank you all for being here as well. So I just want to make sure that was noted. April 29th for pretrial.
Yes, Your Honor. Thank you.
Thank you.
Thank you, Judge.
Appreciate it, Mr. Eller. Thank you for taking the case.
4 other suspects, Keith Fields, 18, Gerard Sykes, 24, Dante McGee, 17, and Tavares Kelly, 17, have also been arrested and face arraignment. In Racine County, Wisconsin, 15-year-old Reed Galinsky is charged as an adult with first-degree intentional homicide for the stabbing death of his mother, Suzanne Galinsky, who was a 4K educational assistant. According to prosecutors, Reed was inspired after watching a Netflix documentary about the Menendez brothers and planned to kill both his parents. On March 4th, authorities say Reed struck his mother twice with a dumbbell to try to knock her out, then stabbed her multiple times in the chest and neck as she fought back. She asked him why, and he replied, pain. He later sent Snapchat photos of the scene to a friend and told her to call 911, then waited for police. When officers arrived, Reed surrendered, telling them plainly, "She is dead from what I did," and asking them to kill him. Inside the home, police found Suzanne with fatal injuries, and attempts to save her were unsuccessful.
Okay. Next is State versus Reed Galinsky appearances.
Brooke Erickson appears for the state. Members of the victim's family are also present in court in the gallery.
Reed Galinsky appears in person with attorneys Francesca Ballesteri and Alex.
We're here for the preliminary hearing. Attorneys ready?
We're prepared to waive the preliminary hearing this morning. I believe co-counsel filed the waiver form.
Investigators also found knives and a dumbbell with blood evidence. According to the criminal complaint, Reed had also planned to kill his father with a hammer that evening, but could not find one large enough. He told investigators he had been feeling depressed and was misusing his brother's anxiety medication to get high.
I do have it. Okay, Mr. Galinsky, did you talk to your lawyers about waiving the preliminary hearing?
Yes, I did.
At a preliminary hearing, the state calls witnesses to testify to prove probable cause that a felony has been committed and that you probably committed it. By waiving the hearing, you're agreeing the state can prove probable cause and I can order you to stand trial on the charges. Did you understand what the waiver meant?
Yeah, I did.
Did anyone make any threats or promises to force you to waive the hearing?
No, I did.
Do you freely, knowingly, and voluntarily waive the hearing?
Yes.
Based on the foregoing and the facts in the complaint, I find there is probable cause that this defendant committed the alleged felony in the criminal complaint. I'm going to bind him over to stand trial on the charge. And then with regard to the arraignment, do the parties want to go forward today?
No, Your Honor. We did file a request for reverse waiver. I believe we already have a date picked out in front of the assigned branch.
Okay, we'll give you a reverse waiver hearing.
Thank you.
Reverse waiver hearing, June 16th at 1:30.
Thank you.
Thank you.
His bond was set at $1 million cash, and he will be allowed supervised contact with his father while in juvenile detention. In a case that drew national outrage, a Memphis jury has acquitted 3 former police officers, Tadarius Bean, Justin Smith, and Demetrius Haley, of all state charges in connection with Tyre Nichols' death. The officers had faced 7 charges, including second-degree murder, aggravated assault, and kidnapping. Nichols, a 29-year-old man, was pulled over in January 2023 for suspected reckless driving and ran from the traffic stop before being caught near his parents' house, where officers repeatedly punched and kicked him. He died 3 days later from blunt force injuries, similar to those seen in car crashes. During the 9-day trial, defense attorneys argued the officers were handling a dangerous arrest in a high-crime area, and that Nichols' refusal to cooperate made things worse.
Court will read the verdict as follows. In indictment 2300241, State of Tennessee versus Tadarius Bean, Demetrius Haley, and Justin Smith, if counsel would like to stand with their clients. The verdicts read as follows. Count 1, second-degree murder. We, the jury, find the defendant, Tadarius Bean, not guilty. Count 1. We, the jury, find the defendant, Demetrius Haley, not guilty. Count 1. We, the jury, find the defendant, Justice Smith, not guilty. Count 2. Aggravated assault, acting in concert. We, the jury, find the defendant, Tadarius Bean, not guilty. Count 2. We, the jury, find the defendant, Demetrius Haley, not guilty. Count 2. We, the jury, find the defendant, Justin Smith, not guilty. Count 3. Aggravated kidnapping with bodily injury. We, the jury, find the defendant, Tadarius Bean, not guilty. Count 3. We, the jury, find the defendant, Demetrius Haley, not guilty. Count 3. We, the jury, find the defendant, Justin Smith, not guilty. Count 4. Aggravated kidnapping with a deadly weapon. We, the jury, find the defendant, Tadarius Bean, not guilty. Count 4. We, the jury, find the defendant, Demetrius Haley, not guilty.
Prosecutors said the officers took out their anger on Nichols and then tried to cover it up. After 8 hours of deliberation, the jury found them not guilty.
Count 4. We, the jury, find the defendant, Justin Smith, not guilty. Count 5, official misconduct, unauthorized exercise of official authority. We, the jury, find the defendant, Tadarius Bean, not guilty. Count 5, we, the jury, find the defendant, Demetrius Haley, not guilty. Count 5, we, the jury, find the defendant, Justin Smith, not guilty. Count 6, official misconduct, refraining from performing a duty. We, the jury, find the defendant, Tadarius Bean, not guilty.
One other officer involved, Desmond Mills Jr., had already pleaded guilty to related federal charges, and another officer, Emmett Martin III, is still awaiting trial. Meanwhile,
We, the jury, find the defendant, Demetrius Haley, not guilty. We, the jury, find the defendant, Justin Smith, not guilty. Count 7, official oppression. We, the jury, find the defendant, Tadarius Bean, not guilty. Count 7, we, the jury, find the defendant, Demetrius Haley, not guilty. Count 7, we, the jury, find the defendant, Justin Smith, not guilty. All verdict forms have been signed by the foreperson. Attorneys, you can have a seat with your clients. Ladies and gentlemen of the jury, you have performed your duty. We appreciate the time and attention that you all have given to this case. We will now excuse you all from the courtroom.
Nichols' family is suing the city of Memphis for $550 million, saying the officers and the city share responsibility for his death. Gregory Moore, accused of arranging the murder of Cleveland Clinic nurse Eliza Sherman more than 10 years ago, was arraigned in Cuyahoga County Common Police Court. He faces charges including 1 count of aggravated murder, 1 count of conspiracy, 6 counts of murder, and 2 counts of kidnapping.
State of Ohio would like to be heard?
Yes, Judge, thank you. Kevin Filiato, Assistant Prosecutor on behalf of the State of Ohio. Your Honor, the state understands that the Bond Commissioner's Office is recommending a $2 million bond in this case. That is what the state recommends at this time. This defendant, Your Honor, planned this ahead of time, obtained the means with which he did this crime. Those means are also means that he used to avoid leaving evidence of his crime. That evidence that he sought ahead of time to not leave behind is the same evidence that clears the person that everyone thinks did this crime, which is Eliza Sherman's husband. He did not. And this defendant sought for, after this crime, he lied to the police, he hid evidence from the police, he got rid of the phone that he used to commit this crime with, and he has lived for 12 years amongst us with everyone believing the husband did this, and that's not true. This case is about evidence. And the evidence in this case shows the defendant planned ahead of time to lure Eliza Sherman to his office, to keep her there under the guise of him being in the office, and he wasn't, and for him or someone working with him to come up and stab her. After the crime happened, this defendant was aided by people who then tried the next morning to get rid of the electronic means that he used. 21 minutes of video footage were missing from inside the building that should have captured this crime, but didn't. And then voicemails that Eliza left when she was at the call box were deleted before the police could get to them. All of these things are to show this defendant planned this crime and then committed the crime. We consider him to be a threat to public safety as well, because when the court system has required him to do his job as a lawyer, he responded with criminal activities, calling in bomb threats to 3 separate courthouses on days when he was supposed to be working there, coming up with illnesses and medical excuses to get out of going to court, a single car crash to keep him out of court, and then this. So, Your Honor, we ask that this court implement the $2 million bond, reserving the right, of course, to ask for higher or potentially no bond in the future. With me today, Your Honor, are 2 of Eliza Sherman's children who would like to make a statement to the court if it pleases the court.
Absolutely.
Moore pleaded not guilty to all the charges. At the hearing, Eliza Sherman's daughter, Jennifer Rivchin, spoke to the court, describing Moore's alleged betrayal of Sherman, who had been his client, as a shocking breach of trust.
Greg Moore stands before this court, charged with the kidnapping and murder of her mother, his own client, a woman who trusted him, a woman who he was duty-bound to protect and advocate for. Instead, He allegedly betrayed that trust in the most horrifying way imaginable. If a person is capable of such calculated violence against someone he had a professional obligation to defend, one must ask, what else is he capable of? We are not just speaking about an alleged crime. We are speaking about a man who, when under pressure, has reportedly turned to criminal behavior in the past. This is not just a matter of personal betrayal or professional misconduct. It is a threat to public safety. It is a threat to the moral fabric of our society. We need to ask ourselves, what kind of society do we want to be? Given what we know of his past behaviors and actions, Greg Moore needs to remain in custody and behind bars. Just imagine what he could do to someone with whom he shares no obligation, no professional relationship, no personal history. If he could do this to our mother, then none of us are safe. Your Honor, I beg. No, I implore you. We have waited for 12 excruciating years. Please set the maximum bond possible. Greg Moore is reckless, unpredictable, and capable of taking extreme measures to fulfill his evil agenda. We cannot take that risk. My mother deserved better, this community deserves better, and justice demands better. Thank you.
No, thank you. Anything further, Mr. Filiatro?
No, Judge, thank you.
Thank you so much. Counsel, anything further?
And we filed a motion for bond. There's some facts that have been stated that we would dispute, but we'll take it up at a later time. It's my understanding that they haven't even interviewed Mr. Moore yet, and so at that point, we have nothing else at this time.
Thank you so much. Not guilty has been entered. This matter has been assigned to the docket of Kira Krivash. First pretrial will be 6/4/2025 at 9 a.m. Bond is set at $2 million, cash, surety, or property. The defendant does have to provide a DNA sample. There is to be no contact in any form or fashion with the alleged victim's family. Mr. Moore, that is in any form or fashion, not through another person, not through social media, anything that you can conjure up in your mind that will result in contact, you need to say to yourself, no. That could just cause other issues before the court. Understood, sir?
Yes, Your Honor.
Thank you so much. Anything further, counsel?
No, thank you, Your Honor.
Thank you so much.
Prosecutors say Moore misled investigators, hid evidence, and got rid of a phone connected to the crime. Judge Deborah Turner set his bond at $2 million. Terriona Pascal, 32, has been sentenced to 23 years to life in prison for the murder of Cleveland State University professor Todd Morgan in Hudson, Ohio. Pascal pleaded guilty to aggravated murder with a gun specification, which meant she avoided a jury trial that had been set to start the previous day. Todd Morgan, a father of two, was found dead on April 19, 2023, after a welfare check at his Hudson home revealed he'd been shot multiple times in the head and torso.
Yes, to his family, I'm very sorry, and I hope that one day that you can find it in your hearts to forgive me. That's it.
All right, Ms. Peschel, I will remind you of a couple of things. First and foremost, did you execute the violent offender database form?
She's going to sign it right now, Judge.
All right.
The tragedy left a deep mark on his family, who gave emotional victim impact statements during sentencing. Morgan's mother told Pascal, "You took a father from two beautiful children," and urged her to truly repent and come forward with the full truth about what happened. Pascal briefly apologized, saying she was sorry and hoped the family might someday forgive her.
Now, I know that you've gone over this form with your attorneys, but I am still going to read it into the record so you are fully aware of your responsibilities. You have been convicted or pled guilty to a qualifying violent offender offense as defined by the Ohio Revised Code. Since you will be sentenced to a prison term, you must enroll in the database personally with the sheriff of the county in which you reside 10 days after your release. You are required to provide to the sheriff certain information, which includes your full name and any aliases you use, your residence, your social security number, any driver's license number or CDL number or state identification number, information regarding the offense of which you have been convicted, and the name and address of any place where you are employed, the name and address of any school or institution of education that you attend, the license plate number of any vehicle owned or operated by you or registered in your name, the vehicle information of that vehicle, and any description of that vehicle, a description of any scars, tattoos, or other distinguishing marks on your person. You are required to provide the sheriff fingerprints and palm prints. The sheriff will also obtain a photograph of you at the time of your enrollment. After the date of your initial enrollment, you are required to re-enroll annually. You must update and/or amend any of the information described above that has changed and provide any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar date on which you are initially enrolled. If you change your residence address during the 10-year enrollment period, you must provide written notice of that change to the sheriff with whom you most recently enrolled, and to the sheriff in the county in which you intend to reside within 3 days of the change of address. You are required to comply with all of these requirements for a period of 10 years after any release, unless your sentencing court determines otherwise. Your expected residence address would be Summit County, therefore you shall enroll upon release to the sheriff's office located at 205 East Crozier Street. Ms. Paschal, failure to enroll or failure to verify any residence at the specified times will result in a criminal prosecution. Do you understand that?
Yes, Your Honor.
All right. In addition, I will remind you that you do have certain appellate rights. They are limited because you did enter into a plea in this matter. However, if you wish to file an appeal, you must do that within 30 days of today, which is your sentencing date. Do you understand?
Yes, Your Honor.
You will be entitled to jail time credit. That number I do not have for you at this point, but it will be reflected in your journal entry. You must pay attention to that when you receive that. Understood?
Yes, Your Honor.
During your time at the Ohio Reformatory for Women, you shall not use drugs, alcohol, or illicit substances, and you may be subject to random testing for that while you're incarcerated. Do you understand?
Yes, Your Honor.
All right.
The judge noted that her guilty plea spared Morgan's loved ones the trauma of a trial, though it could not ease their pain.
I'm sentencing you to a period of 20 years to life on count 1, aggravated murder and unclassified felony. In addition, that sentence will run consecutive to the 3-year firearm specification, which is attached to that count 1. That firearm specification 3-year sentence must be served first, it must be consecutive, and it is in fact mandatory. This will make you eligible for parole, which there's no guarantee of that, at the earliest at 23 years, but you could serve up to life in prison for this matter. Do you understand all of that, Ms. Paschal?
Yes, Your Honor.
All right. I will reiterate that the parties did reach this joint recommendation, and it was provided to the court prior to the acceptance of the plea, and it was, I would say, poured over by many of the people involved. So I am following that for all of those reasons. Did I forget anything on behalf of the state?
No, Your Honor, thank you.
On behalf of the defense?
No, Your Honor, thank you.
All right. At this time, I'm going to execute the violent offender database form, and we will file that. I'm going to have it made part of the record. Thank you, everyone.
Originally, Paschal faced several charges from a Summit County grand jury, including aggravated murder with a weapon specification, 3 counts of murder, tampering with evidence, aggravated robbery, misdemeanor theft, and attempted theft. 15-year-old Shaun Hill Jr., a standout athlete at Minneapolis North High, was walking home on February 9th, 2022 when, out of nowhere, 30-year-old Cody Forhencom pulled a weapon and fired at the back of his head 3 times, taking his life instantly after they had briefly crossed paths on the sidewalk. Before the sentencing, Deshaun's dad spoke in court, thanking the community and calling for justice, urging the judge to hold Forhencom fully responsible.
My daughters, hold on, my daughters. I must talk about how you impacted his little sisters. First of all, he got a little sister named Ashanti, and she's 10 years old. She's devastated. Her brother used to do TikToks with her. She can't do a TikTok with her brother no more because on the street, he got another sister. She's 11. She's she's going downhill because of her brother. She's doing stuff in school that she never did because this dude, her brother was like a protector to them, me and him, everybody in our village. My son didn't deserve to. You should, excuse me, but hold on.
Thank you.
I'm missing out on him going to prom. Missing out on him graduating high school. All because of what? Because of him getting mad because a white dude beat you up in the store? I guarantee you, everybody seen that was a white dude. And I guarantee you know Shaun, my son, didn't do nothing to you. I guarantee you never seen him in your life. Only a coward, nobody, no, you're a nobody, dude. Like, how is you still sitting there? Like, only reason you did this is because you was a street. You couldn't afford to live your own life. And you did that because right now, them people gave you a shirt to wear. You didn't never have nothing in your life. You was always a nobody. And that's all you will ever be is a child. That's all you gonna be.
Please address me what sentence
I'm
you'd like.
done. And I'm done. Thank you.
Thank you, Mr.
Your Honor, there's one other thing.
Yes, and hold on. If there are outbursts from the courtroom, you will have to leave the courtroom. Please, no outbursts from the courtroom. You may proceed.
Thank you, Your Honor. I'm William Walker, the family attorney. I have actually spoken to Tuesday Shepherd and D. Hill Sr. I've known this family for well over 10, almost 15 years, since D. Hill Jr. was a young child. And the way this case came about, a few things need to be pointed out and be very clear on the record. Number one, this man took their son's life, their only son. And it's significant for this court to know that this was not only their only son, it was their number one hope. When I tell the court that D. Hill Jr. was an A.B. honor roll student, D. Hill Jr. was liked by just about, in fact, every single person in the school system at North High School, principals, teachers, his classmates. He was viewed as a mentor to other young kids. He was active in football, active in basketball. He had scholarship offers, recruiting offers.
He's still getting them today.
Every single day. And I've plowed through 50, 60, 70 offers to bring D. Hill, to give him the opportunity to move forward. And the family knew this all along. There were offers for him to go to private schools, for him to do other things. But D. Hill and the family, there's a long list of family members that have attended North High School. D. Hill decided that he wanted to be a North High Polar. And that's what he did. And on this particular day, this random by the defendant, who came up and senselessly this man's son in the back of the head, is ridiculous, and it cannot be ever misunderstood as to the pain that this dad feels as a black man, as a father, as a parent, as he has two young sisters. His two young sisters, they talk about eating hamburgers with their brother. D. Hill talked about the TikToks that they would make at night on Saturday nights, Friday nights, every night. None of this can ever happen again. None of it. Because this gentleman walked around North Minneapolis on this day after getting beat up, looking for someone to harm, and a young person. And Miss Tuesday Shepherd has asked that I relay this information because it's difficult for a mom for a dad to share with the court and convey the pain that they experience, that they feel every day, nearly getting kicked out of a courtroom by deputies because they're in pain. They are deeply hurting, Judge. They've asked for the maximum penalty under law, and we would respectfully ask that you, as the judge, jury, show no mercy on this defendant, show no mercy on this defendant, and issue the maximum penalty under law. Thank you.
And more.
In January 2023, a jury wasted no time, just about an hour, and found Forhincombe guilty of 2 second-degree murder charges. Then, on February 28th, Judge Julie Allen sentenced him to 463 months in prison, the maximum allowed by state law. DeLaunt Hardy appeared in court Monday, facing aggravated murder charges tied to the deaths of Cleveland police officer Jamison Ritter and Hardy's grandmother, Beatrice Porter. He pleaded not guilty, and the judge set his bond at $10 million. According to prosecutors, Hardy stole a weapon from his grandmother and fired at her in the face, leaving her body to be found by her husband.
Good morning, ladies and gentlemen. Today it is my duty to advise you of your constitutional rights. These instructions are important, so please listen carefully. Under the constitutions of the United States and the state of Ohio, persons charged with the commission of an offense are guaranteed certain basic rights. They are the right to know and understand the charges against you, the right to a speedy trial, the right to a trial by jury. You may waive or give up that right and have your case tried by a judge without a jury. At trial, the state of Ohio has the burden of proving your guilt with evidence beyond a reasonable doubt. You have the right to meet your accusers face-to-face and to cross-examine witnesses for the prosecution. You have the right to summon or subpoena witnesses on your behalf. You do not have to testify against yourself. You have the right to counsel. If you are unable to afford an attorney, the court will appoint a lawyer to defend you. You will be assessed a $25 fee for an appointed attorney. You will not be denied an attorney if you are unable to pay this fee. At the end of your case, you may be ordered to pay the fee if your judge determines you are financially able. If you choose to hire your own attorney, you have the right to a reasonable continuance to hire one. This morning, you are not here for the trial of your case. You are here for your arraignment. An arraignment is your opportunity to be informed of the charges against you, for a bond to be set, and for you to enter your plea. You do not have to make any statement about the charges against you, but any statement made may be used against you. As your name is called, please step forward. You will be asked when you receive a copy of the indictment or information and whether or not you understand the charges against you. By law, you have 24 hours before you must respond to the indictment or information. If it has been less than 24 hours since you received a copy of your indictment or information, but you wish to be arraigned anyway, if you are placed on GPS electronic monitoring or an alcohol monitor as a condition of your bond, you will be required to follow all the rules and conditions of GPS electronic monitoring. Specifically, any unapproved leave, late return, or being in an unauthorized location may result in your warrantless arrest. Failing to properly charge or not charging your unit may result in your warrantless arrest. Tampering with or otherwise damaging the unit may result in your warrantless arrest. You understand that you may be arrested without a warrant if you violate any bond condition or rule of GPS electronic monitoring. You must sign the GPS electronic monitoring rules, which will be explained to you prior to your release as a condition of bond. When GPS electronic monitoring is ordered as a condition of your bond, you will be asked by the judge if you were listening to these instructions regarding GPS monitoring, if you understand the rules allow you to be arrested without a warrant, if you violate the terms of GPS electronic monitoring, and if you understand that you must knowingly, voluntarily, and willingly sign those rules prior to your release. Finally, pursuant to revised code section 2937.99, if you do not appear in court as ordered after being released on your bond, you may be charged with a felony of the 4th degree. Inmates in the county jail have the right to be present in the courtroom. Officer,
We're okay here, Your Honor.
Okay, thank you very much.
A few days later, on July 4th, around 1:30 a.m., officers went to East 80th Street to arrest Hardy on a felonious assault warrant related to Porter. When they confronted him as he left a house, Hardy tried to get away on a bicycle and then allegedly opened fire, killing Officer Ritter.
Well, we can call the first case.
Start with the jail 693409, Monte Hardy.
Good morning, Your Honor.
Good morning.
Attorney Alyssa Barboski from the Public Defender's Office will enter a not guilty plea, acknowledge receipt of a copy of the indictment, waive reading of it, and any defect in time or service. As to bond, we are asking that that be set. As to counsel, we are asking to be assigned as one of the attorneys on the case as two are needed. We did meet with him in the jail prior to this and have built a rapport with Mr. Hardy, and we are also asking that we represented him in the municipal court, so we are asking in exchange for one of our other cases to be appointed to other counsel that we would be assigned to this one as one of the counsels.
Yes, Judge, thank you. Kevin Filiatro here on behalf of the state of Ohio. Your Honor, I understand what the bond recommendation is for this defendant. The state of Ohio is asking for his bond to be set at $10 million. The state gives notice that it will be filing a motion to have him held without bond once we know who the trial judge is. And the reason for that is this: there are no circumstances under which, if this defendant is released, the public is safe. On June 28th of this year, Your Honor, this defendant used a gun he stole from his grandmother to shoot her in the head in her own home, and then left the scene stealing her husband's bicycle. July 4th of this year, the defendant was at a house on East 80th Street in Cleveland. He was surrounded by police who were there to arrest him on the warrant for felonious assault from Garfield Heights. He knew they were there. He exited the home, got on that bicycle. In one hand were two swords, and in his left hand was that same gun he had stolen from his grandmother and had shot her with. Police tried to arrest him in a manner in which he would stay safe. And instead, he fired 4 rounds, the first round hitting Officer Jamison Ritter, him. The second round going right past Officer Logan Weber's head. The third round going in between Officer Russell May and Officer Brittany Vajussi. And the fourth round being shot while 5 officers held his hand to the ground while still clutching. This defendant poses an immense risk to the public and should not be released. With me today are members of Cleveland Police, Russell May, Logan Weber, Detective Hudson with the Homicide Unit, and other members of Cleveland Police. I've spoken with Beatrice Porter's husband. She is this defendant's grandmother, who he is now alleged to have killed. She later that same day on July 4th from the I've also spoken with Officer Ritter's family, and here's what they would like the court to know. We wish that he be prosecuted to the fullest extent of the law and he can get the highest bond possible. And they have faith in the criminal justice system.
Yes, I can. Do I have permission to speak freely?
I would advise you not to speak on the indictment or any of the allegations in this case, but you may go ahead.
Mr. Hardy, this is Attorney Alyssa Barboski. Remember when we talked on Friday, how we just said we're just going to go through everything and enter a not guilty plea and we don't wish for you to talk at this time? We'll come visit you in the jail for a sign to the case and we can talk further, okay?
But I do want to pull up evidence from my laptop and my cell phone.
I don't want to talk about that right now. We can talk at a later time about that, okay? That's not appropriate for this morning, okay?
All right.
Thank you.
All right, Mr. Hardy, I have a few questions for you. Do you have an attorney?
Yes.
Who is your attorney, Mr. Hardy?
I don't have one that's that I pay for. I have the attorney that's representing me now.
Okay, so you do not have the money or other means to hire your own attorney?
Not at this moment.
Okay, Mr. Hardy, have you received a copy of your indictment?
Yes.
And have you read and understood the indictment?
I'm dyslexic, so it's hard for me to actually read from time to time.
Okay. Do you understand what you're being charged with, Mr. Hardy?
Yes, she read it off for me. Robbery and a cop and foster parent.
Okay. Mr. Hardy, at this time, I am going to assign counsel to represent you. I'm going to assign the Office of the Public Defender, as well as Attorney James Ingalls to represent you. Because of the nature of these offenses alleged, the court will assign 2 attorneys to represent you. Your bond is set at $10 million. That is a cash surety property bond. You're ordered to have no contact with the surviving victims or any of your family, considering the victim's family is your family. I accept your not guilty plea. Your case is assigned to the docket of Judge Ashley Kilbane. First pretrial is on July 24th at 9 a.m.
Prosecutors said Hardy was carrying 2 swords, along with a stolen weapon, as he tried to flee. He was arrested soon afterward. Watch how this judge gets really mad when an officer messes up a report.
Williams? The judge sounds like there's no probable cause because US 50 is not in Harris County, Texas. That's what the road they said it happened on. Where is it? It said US 50. That's not in Harris County.
And the DIMS does say 200 block of South US.
Are you serious? Do I need to look it up? I don't know.
Your Honor, the DIMS further says during the scene of the accident, which occurred on 200 block of South US 59 freeway, Harris County, Texas. But counsel is correct that before they said he responded to a major crash call for service on the 200 block of South US 50 freeway. So they put 50, but then later in the DIMS, they did put 59. So they're just 2 addresses, so I don't know why that's there. But they did say the accident occurred on US 59.
Well, that would be a different story. Do you have any other evidence that is pointing to that it's at 59 or is it 50?
So, Your Honor, the only thing we have is that statement from the officer which states that the accident occurred on 200 block of US 59 in Houston, Texas 77004.
Is that what really happened or was it on 50?
So that's what I can explain is the officer put...
I'm not working on hunches here, man.
And I understand, Your Honor. The officer initially said he responded to a crash call for service which occurred on US 50, but then later said the accident occurred on 59. So let me see if we...
definitively point where it is.
I'll check the OR and see if they clarify in the complete OR. Yeah, this is really good. And in the OR as well, the officer says, which occurred on 200 block of US 50, Houston, Texas 77004.
So is 50, it's not in Harris County?
He switches between 50 and 59 in the offense report, Chief.
I know, probable cause.
Yes, Judge, and we understand.
All right, Joe. Thank you, Judge. All right, Mr. Lozano, be careful out there. You know what I mean? Really. Just listen to, he's great. He'll help you out whenever you need, you know? All right, man. Good luck.
In the end, the judge decided there wasn't enough evidence and let the suspect go with a warning. Sheldon Timothy Harrington Jr. is standing trial for the murder of Ole Miss student Jilly, who disappeared in July 2022 and was later declared dead. Prosecutors say Harrington enticed Lee to his apartment where they'd been snapping back and forth, then looked up. How long does it take to strangle someone? Just before Jay showed up. Security footage caught Jay heading to Harrington's place before the disappearance, and later showed Harrington jogging near Jay's abandoned car.
When we concluded yesterday, Mr. Baker was on cross-examination. Mr. Baker, you remain under the same oath and you may continue your cross-examination.
Thank you, Your Honor. Mr. Baker, Detective Baker, we stopped yesterday
in the examination pertaining to the certain ping locations of Jilly's phone, and I asked you to chart out due to the fact that you can do that based on your training, and you have an opportunity to do that.
I did.
All right. And I believe this exhibit 106, if you look at it, please. Did you have an opportunity to compare your latitude and longitude coordinates with that exhibit 106 and determine whether or not it's accurate?
Yes, I did type in the latitude, longitude coordinates of those last 10 pings that you asked me to do, and for the most part, they look fairly accurate. Our maps looked a little different, mine, but with a point or two.
I'm on the same page as everybody.
He also bought duct tape, grabbed a shovel and wheelbarrow, gave inconsistent accounts to police, and then left town, all while investigators pieced together his digital trail and behavior.
I want to make sure I was on the right page. Go ahead.
Those coordinates plotted on that exhibit 106 are consistent with the plottings of the coordinates that you compared when you plotted them yourself, correct?
Yes, just putting the lat and long from the CDRs, not giving into account of the radius and the range of measurements like CDRs are supposed to be done.
I move into that.
Any objection? I hear no objection, so I'm going to say there is none anyway. All right, 106 will be admitted.
So that pertains to, those plotting points pertain to the lat and long of the ping locations based on, consistent with the other ping locations that you testified about earlier in this trial yesterday, correct?
Which ping locations are you talking about?
Ping locations.
No, they're not all consistent with all of the ping locations. No, the phone locations are different.
I'm asking about the ping locations. You charted it in the same manner that you charted the previous ping locations that you introduced in the evidence, right?
Yes.
Okay, that was my question. I want to ask you a little bit about a couple of things. You were familiar with the fact that, I believe on this exhibit 106,
Harrington denies everything. His first trial ended in a hung jury in December, and after Jay's remains were found in February, he was hit with a new evidence tampering charge.
has the Lafayette Place on here, correct?
I have to look at it again.
I believe it does. Is Lafayette Place located on that?
Do not see it.
Okay. So can you tell me whether or not you were able to locate ping locations of Jaylee's phone at close proximity to Lafayette Place during the course of your investigation?
Yes, as I last has told you, that those are just the lat longs that AT&T gave. Now to properly, and that's just a guess of AT&T. You've got to take the radius and everything into effect, the sector tower, the side of the sector, so forth. You've got to take all that into effect. So that's just the range. You've got to take the range, be able to plot all that out, not just the lat long that the AT&T gives you.
My question was, did you plat the latitude and longitude of the ping location from the towers at Lafayette Place and indicate that in that area that his phone was located in that area, yes or no?
Yes.
Okay, thank you. And you also, during the course of your investigation, found yourself reviewing certain search warrants pertaining to evidence there at Lafayette Place, like the lockout. Did you review the lockout and search warrant information?
I was told about it, yeah.
You haven't seen it?
May we approach?
You may.
The retrial is on the horizon. In September 2021, 39-year-old Antoine Suggs took the lives of 4 people: Jasmine Sturm, Matthew Pettis, Lois Foreman III, and Natosha Flug Presley, inside his Mercedes in St. Paul. Afterward, he called his father, Darren Osborne, who drove with him to a cornfield in Wisconsin and helped leave the bodies in the SUV. Antoine was found guilty in March 2023 of 4 counts of second-degree murder. In May, he was sentenced to 103 years and 8 months in prison, serving each sentence back-to-back, ensuring he'll spend the rest of his life behind bars.
Before I pronounce sentence, I do have a couple of comments for the parties. This is a tragic event. No way to slice it. There's no other way that you can say it. And Mr. Suggs is right. It's a tragedy for 5 families because Mr. Suggs' family also is feeling this tragedy and feeling what's happening. This court has thought long and hard about how I would discuss with you all and Mr. Suggs this sentence. And as I sat here and listened to your victim impacts, I can tell that there is a lot of pain and hurt that you suffered. And you are right that you will not get your loved ones back in the physical form, but as you were telling your victim impacts, the smiles that you had as you talked about their memory and what they've done and what they've meant, I want you to hold on to that because that is what's going to persist on. You're never going to get an answer to why Mr. Suggs did what he did. And I will talk to Mr. Suggs now. Mr. Suggs, it's clear to me that you truly believe that you acted in self-defense. It's clear that this is your belief as you're in trial. It's clear that this is your belief here today. You did testify, and you testified under oath, and you had an opportunity to tell what you believed in your story of what happened that night on September 12th. Having been found guilty by a jury on April 3rd, 2003 to the crime of second with intent not premeditated in violation of Minnesota Statute 609.19 subdivision 1, parens 1, as charged in count 2 of the complaint and standing convicted of that crime upon the verdict of the jury. The court hereby adjudicates and convicts you guilty of that offense and is therefore the judgment of the court in the sentence of the law that you be committed to the Commission of Correction of the State of Minnesota for a term of imprisonment of 306 months. That is minimum incarceration, 204 months, maximized supervised release of 102 months. That sentence will run consecutive to count 1 of the complaint of the conviction. It is further ordered that you will be delivered immediately to the Commission of Corrections of the State of Minnesota. As it relates to count 3, having been found guilty by a jury on April 3rd, 2023 of the crime of second degree with intent not premeditated in violation of Minnesota Statute 609.19 subdivision 1, parens 1, as charged in count 3 of the complaint and standing convicted of this offense, is thereby the judgment of this court in sensitive law that you be committed to the Commission of Correction of the State of Minnesota for imprisonment of a term of 306 months, minimum incarceration 204 months, maximized supervised release 102 months. The court will note that that will be consecutive to count 2 in this matter. And restitution will be reserved for 90 days on that issue. Having been found guilty by a jury on April 3rd, 2023 to the crime of second-degree murder with intent not premeditated in violation of Minnesota Statute 609.19, subdivision 1, parens 1, is charged in count 4 of the complaint and standing convicted of that crime upon the verdict of the jury. The court hereby adjudicates and convicts you guilty of that offense. It is thereby the judgment of the court in sentence of law that you be committed to the Commission of Corrections for the State of Minnesota for imprisonment of a term of 306 months, Minimum incarceration, 204 months. Maximized supervised release of 102 months. Against, the court will note that that will run consecutive to count 3. The court notes that the big decision I had to make was whether or not this would be consecutive or concurrent. And as I went back and forth, each one of these individuals, Natasha, Jasmine, Matthew, as well as Lois, deserves that you serve time for each one of them. And that's 101 years. I recognize that. And I lost sleep over that. I lost sleep wondering, is there something I could do to perhaps give you an opportunity to be out in the community? And is there something that is redeeming that will allow that to happen? And as I listened to your statement at the end, there was no sorry for your loss. There was no understanding that while you truly believed that this was self-defense, that there are 4 families grieving loved ones. You, throughout this trial and throughout this sentencing, cast blame on others. And this is a sentence in which you now have to take the responsibility for the acts that you have done. You cast blame on your father for the aftermath of what happened, and you testified you didn't remember something so significant. You cast blame on Jasmine and Matthew and Lois and Natasha for their deaths. But make no mistakes, you caused their death. You pulled the triggers. You put them in their graves, and for that reason, you will serve this time. With that, that does conclude the sentence, and you can head back with the deputies. Good luck to you.
I love y'all. It's not over. It's not over. We love you.
His father, Darren Osborne, also known as McWright, pleaded guilty in December 2022 to helping hide the bodies and was sentenced to 5 years in Minnesota. Earlier in 2025, he was also sentenced to 16 years in Wisconsin, which he'll serve at the same time as his Minnesota sentence. Cleveland Browns. Rookie defensive tackle Mike Hall Jr. pleaded no contest in Avon Lake Municipal Court to a reduced disorderly conduct charge after a domestic violence incident last month. The case began on August 12th when Hall's fiancée accused him of shoving her, dragging her outside, hitting her with a baby bottle, and threatening her with a weapon. Police found damage to doors in the home and seized 2 firearms, though the woman didn't ask for medical help. Hall was arrested the next day for domestic violence, but his fiancée later recanted parts of her story, saying she was mistaken about Hall holding a weapon to her head.
Okay, thank you, Mr. Craig. Attorney Spellacy, Mr. Hall, my understanding is that you wish to accept this offer and plea deal from the prosecutor?
That's correct, Your Honor.
Okay. Before I decide whether to accept this, my understanding is the victim's representative attorney is here in the courtroom. I want some assurance that the victim is been made aware of this hearing today, has had an opportunity to be heard, and that she's in agreement with this. So, counsel, can you kind of introduce yourself? And
yes, Your Honor. For the record, Eric Long on behalf of the victim. Your Honor, I have had extensive opportunity to speak to the victim about this case and her issues. I understand she has also had extensive communications with the prosecutor in this case. It is her desire to move forward with this case, and she has previously asked that the case be dismissed. We understand that Mr. Craig and the city has declined to do so. We understand that. So with that in mind, this resolution is something that my client is comfortable with and does want to proceed.
Okay. And she does not wish to be heard today on the record?
She does not.
Okay. All right. Thank you, Mr. Long.
Thank you.
Your Honor, just briefly, she has cited issues, technology,
Judge Allison Manning handed Hall a suspended 30-day jail sentence and placed him on 2 years of probation, warning that any future charges could land him behind bars. He was also fined $250 plus court costs.
Mr. Craig, Mr. Spellacy, do you wish to be heard?
Thank you, Your Honor.
Judge, first of all, we're appreciative of the resolution that we were able to reach here. I can tell you that this is an unfortunate incident, but from every incident, you can always learn something. I can tell you that Michael has taken steps to better himself regardless of what brought him here. I can tell you, Judge, that he is in some counseling, if I can approach him.
You may.
And 3 different letters, 3 different dates from somebody that he's working with. I think it'd be informative for the court to take a look at those.
Thank you.
Instead, can I ask that those not be made part of the?
Yeah, I agree. I think that they're protected, so they won't be made part of the official record.
Thank you very much, Your Honor. Judge, having said that, there's, we're grateful for the resolution, and I can tell you that he's, whatever the court does, we're ready to accept. Thank you.
Thank you. Mr. Attorney Long, is there anything else that you feel the victim wishes to be heard on before I impose a sentence?
No, Your Honor.
Mr. Gray, are you seeking anything in regards to sentence or?
Judge, I would satisfied. I would ask that in our discussions, I would ask that suspend the sentence.
The fiancée, through her lawyer, supported the plea deal but did not speak in court. Hall, who is currently on the NFL Commissioner's exempt list and barred from practicing or playing, expressed regret and said he would pursue counseling.
Mr. Hall, certainly now's your opportunity if you'd like to say anything before I impose a sentence.
First and foremost, I'll just say I just regret this whole situation and I wish it just never happened, but just taking those steps and just receiving counseling and just trying to better myself. Thank you.
I think that's reflected here in these letters that your attorney submitted to the court, that you are taking a lot of steps in order to improve yourself and improve maybe the relationships of the people
Yes, sir.
that are in your life. And so I'm really glad to see that that's happening.
Yes.
All right, it'll be the sentence of the court that the court will impose a 30-day jail sentence, but the court will suspend all of the jail sentence, meaning you will not serve any jail time, on the condition of 2 years of monitored time of good behavior. If I see you back at the court, it doesn't matter if it's specifically domestic violence, disorderly conduct. If you are charged with any new criminal charges in the next 2 years, that'll be brought to my attention, and the court will have a review hearing, and the court could impose some or all of that suspended jail time. Do you really understand so far?
Yes, sir.
All right. With regards to the fine, it'll be a $250 fine that will be imposed, plus the court costs. Anything further, Mr. Spells?
No, Your Honor. Thank you very much.
Mr. Hall, anything else you wanted to address with me today, or any questions you want me to answer?
No, Your Honor.
All right, that concludes the hearing. Thank you.
Thanks, Judge.
While this plea ends the criminal case, the NFL is still reviewing the incident, leaving Hall's football future uncertain. Robert Brooks, a 43-year-old inmate serving a 12-year sentence for assault, died after being brutally beaten by corrections officers at Marcy Correctional Facility in upstate New York last December. Brooks, who had recently arrived there, was repeatedly attacked, even while handcuffed, suffering catastrophic injuries. Body camera footage of the violent assault has sparked widespread outrage over abuse in prisons. Prosecutors have charged 10 correctional officers, 6 with murder, 3 with manslaughter, and 1 with evidence tampering.
Mr. Walworth, you were assigned to work in the Arsenal area of Marcy Correctional Facility on December the 9th, 2024, is that correct?
Yes.
Did you leave your post inside of the Arsenal area on December the 9th against departmental policy and procedures upon the arrival of Robert Brooks?
Yes.
Did you and your fellow corrections officers, Nicholas Kiefer, Nicholas Anzalone, and Robert Kessler, assault Robert Brooks outside of the Arsenal on December the 9th, 2024?
Yes.
During that assault, did you put Robert Brooks in a chokehold against departmental policy and procedure?
Yes.
On December the 9th, while in the emergency room of the Marcy Correctional Facility, did you and other corrections officers assault Robert Brooks?
Yes.
During that assault, did you strike Robert Brooks about his body?
Yes.
And did you intentionally strike him in his groin?
Yes.
Were you aware at that time that striking an incarcerated individual in the groin is against departmental policy and procedure?
Yes.
Is it correct that you never reported the use of force that was used on Robert Brooks near the Arsenal area at Marcy Correctional?
Yes.
Is it correct that you never reported the use of force that was used on Robert Brooks in the emergency room at Marcy Correctional?
Yes.
You were aware, sir, were you not, that you were required to report any and all uses of force on an incarcerated individual, whether justified or not?
Yes.
And nevertheless, you lied about the use of force used on Robert Brooks on December the 9th, 2024.
Yes.
And sir, at the emergency room, you did nothing to prevent the assault or protect Mr. Brooks. Is that correct?
Correct.
And you realize that these repeated assaults caused serious physical injury to Mr. Brooks and resulted in his death?
Yes.
People are satisfied, Your Honor.
Thank you, counsel. Mr. Walrath, how then do you plead to the second count, manslaughter in the first degree, guilty or not guilty?
Guilty.
During a court hearing, one officer, Walrath, admitted to choking Brooks, hitting him in the groin while he was in the emergency room, and then lying to cover it up. Brooks's son later spoke about the irony of Walrath now facing prison time himself, pointing out how terrifying it must be to experience the same system he once helped enforce. He also expressed hope that Walrath might find a chance to rehabilitate, something his father was denied.
How old are you now, Mr. Walrath?
36.
And you can read and write the English language, correct?
Yes.
You're a citizen of the United States?
Yes.
Do you have any physical or mental problems that could prevent you from understanding what you're doing here today?
No.
Did you consume any kind of medicine or alcohol before coming to court that could affect your understanding?
No.
You're not currently on any form of probation or parole, are you?
No.
By pleading guilty, you are giving up your right to have a jury trial. Do you understand that?
Yes.
At a jury trial, you would be presumed innocent and you would be entitled to the following rights: to be represented by your attorney, to confront and cross-examine witnesses presented by the government. You'd have the right to remain silent and not incriminate yourself. You would have the right, but would not be required, to call witnesses, or you could testify on your own behalf. You would also have the right to require the government to prove your guilt beyond a reasonable doubt to a jury of 12 people who would have to be unanimous in finding you guilty. Do you understand? You have each of these rights, and by pleading guilty here today, you're giving up each of these rights.
Yes.
You understand, by pleading guilty, you're also giving up any defense you might have to these charges.
Yes.
Now, a plea of guilty is the same as a verdict of guilty rendered by a jury after a trial. Do you understand that?
Yes.
Other than the plea and sentence agreement I spoke of earlier, has anyone made any other promises to get you to plead guilty?
No.
Did anyone threaten you or force you to plead guilty?
No.
Have you entered this plea today voluntarily and of your own choice?
Yes.
You understand that those that are incarcerated for a felony conviction do lose their right to vote in an election until such time as they are released.
Yes.
And now lastly, sir, part of your negotiated plea here does require that you waive your right to appeal. As a defendant in this court, if convicted, you have a separate and distinct right to appeal a judgment of conviction to a higher court in Rochester known as the Appellate Division. There you can, with your attorney, and a free one if you cannot afford it. You can file a brief and argue before that court that there exists some problem with your conviction here in this court. That is a right you have. It's also a right you can waive or give up, and it is being required that you waive your right to appeal on condition I give you the sentence promised to you. That means your conviction and sentence in this court will likely be final, so there's then little you can do to go back after the fact to try and change that. You will have thereby significantly limited your options for appeal in the future. Do you understand?
Yes.
Have you spoken with your attorney about waiving your right to appeal?
Yes, I have.
Do you then agree to waive your right to appeal on condition I give you the sentence promised?
Yes.
And are you doing so voluntarily?
Yes.
I'm holding up for you a document entitled Waiver of Right to Appeal. Halfway down the page, I see the signature Christopher Walrath. Did you sign this document here after reading through it and reviewing it with your attorney?
Yes.
Based upon the defendant's statements and his demeanor here in court, I find a knowing voluntary plea with a factual basis. I will direct the clerk to enter the plea into the minutes of this court to adjourn sentence until.
Special Prosecutor William Fitzpatrick stressed that Walrath, who had been a corrections officer for over 10 years, now faces up to 15 years in prison, a dramatic twist of fate.
July 16th, Your Honor, it was my understanding that the people were not going to object to our request to have the sentencing take place on August 1st.
I know you did need that vote. You don't have any objection going out there?
No, August 1st is a Friday, Judge. I don't know if counsel prefers August 4th, which is a Monday. And we have no objection to him remaining out, getting his affairs in order, and I've also discussed that with the family.
We appreciate that, and we would prefer the 4th.
All right, then. August 4th at 9:30 a.m. for sentencing. And you're going to remain out on the bond that you posted, Mr. Walrath, but that's going to be with some conditions attached as part of our plea agreement here. Condition 1 is you do have to meet and cooperate truthfully with the probation department as they prepare your pre-sentence investigation. Condition 2, you have to come back to the court on any date you're required to be here. As of right now, you know that's August 4th at 9:30 in the morning to be sentenced. The third condition is you must commit no offenses. There are to be no new arrests of any kind between now and the time of your sentencing. Do you understand each of those conditions?
Yes.
If you fail to abide by one or more of those conditions, I would not be bound by the sentence agreement. I would not permit you to withdraw your plea, and I would be authorized to sentence you to any term my law permits. You understand?
Brooks's family has filed a federal civil rights lawsuit against 17 defendants, most of them current or former Marcy staff, demanding justice for a killing that exposed deep failures in protecting the dignity and safety of incarcerated people. Thank you so much for watching. Don't forget to subscribe and hit the notification bell so you can stay updated with our latest videos.